For you that have not met me, I'm Carrie Hermeling. I am a commercial litigation partner in the St. Louis office. So I practice foreclosure law in Illinois and Missouri. Joey Lubinsky is a real estate transactional lawyer / foreclosure lawyer in Colorado. We both have handled dozens of foreclosures over the years. And in the context of foreclosures, we certainly cover judicial, non-judicial, and deeds in lieu. We will provide today an overview that will hopefully give you the tools to advise your client on what would be the best options given their specific situation. And we will cover mostly the states that we're in, because this is unlike real estate transactional law, where many of our lawyers practice all over the globe, all across the United States. We do find that this particular area of law is one which does not always have the uniform code of regulations across the United States, and there are very state-specific issues. So certainly we recommend that in the connection with a foreclosure, you do check with somebody who is local, someone that has been practicing in the area. So let's move on. I'm going to cover the first half, which is foreclosures judicial, and Joey's going to handle the non-judicial and deed in lieu. So the first question is, many of us in our states have either always have judicial foreclosures, but some states provide what's called a non-judicial foreclosure, and it is effectively a private type contractual right that is within the deed of trust documentation. We have in here that it's administrative as well because of Colorado, which really has a quasi process for a non-judicial foreclosure, where they have the combination of the loan documentation as well as the involvement of a public trustee. But I'll have Joey cover that. At the end of the day, and really with the analysis, what the lender is going to ask is, how do I get access to this property, and how do I turn that property into proceeds so I can pay off the debt? These are remedies which are available to the lender when the borrower is usually in default, sometimes not, but fairly close in a financial stressful situation. And this is a tool that the states have allowed to involuntarily sell property that's been secured with the debt, and effectively through a title process terminate the owner's equity of redemption. And in most states, you've got obviously the judicial foreclosure option, which is effectively litigation. In some states you've got the non-judicial, but at the end of that process, the goal is that the purchaser at the sale will either have a trustee's deed in hand or a sheriff's deed in hand, and your lien, which was your mortgage or your deed of trust, will cease to exist, and the purchaser becomes the owner of the equitable interest in the property, and that equitable interest does then ripen to legal title if the owner doesn't defeat it by redemption. And we're not really covering redemption today, but real quickly, redemption is either statutory or equitable, and you'll have to check with the specific state in terms of what those requirements are. They can be incredibly strict, because the goal is to allow the lender to obtain clean title as quickly as possible. But there are many times post sale remedies that are available. The IRS could potentially have a lien and some ability to collect. You've got certainly fraud that would allow for some kind of equitable type of redemption rights in some states. So in our footprint, we've got Illinois, Kansas, and Wisconsin. God love them. We love those states, but judicial only. And that really is a long process, and we'll cover that at the next slide. The non-judicial option is available for our other states. And in Missouri, for example, you can literally have a default, accelerate the debt, and be the owner of the property within 45 days. So an incredibly swift tool for any lender. And the ability for the borrower to stop that process is very limited. Injunctions are not favored, and it is a really an incredible tool for lenders that's used very often. I mean, 99% of all of our foreclosures in Missouri, for example, are non-judicial. In terms of the last point, that's really what I had mentioned before, which is, regardless of whether it's judicial or non-judicial, just check with somebody on this call, or certainly Joey has a 50-state summary in terms of the mortgage foreclosures and deed of trust foreclosures, but you do want to certainly check with somebody local. And if you've always been dying to sell property on the courthouse steps, this is your opportunity, because foreclosures can provide that to you. And it's, there's lots of war stories you can imagine in terms of bidding at the courthouse steps. So before we get to that, let's talk about the judicial process. It is a lawsuit. So for all of those transactional lawyers on this call, you will want to hire somebody in the firm who is doing litigation, because this likely will be a commercial litigation that is filed in the circuit court. You do file a notice of lis pendens, which everyone knows is the recorded document for any lawsuit which relates to a decision that's going to impact real property. That's strictly so that a third party cannot purchase this property without being on some type of notice of this lawsuit. So that's number one. Before you file the lawsuit, you file your notice of lis pendens. Secondly, you decide who are the necessary parties. Well, you only have to really extinguish the interest of the mortgagor, the borrower, or anyone in possession. And that may seem easy in terms of who you would include, but the fact of the matter is, judicial foreclosure is only going to give you title for people or entities that were added as parties. So I've been involved certainly with situations where you file the lawsuit, the creditor has added everyone, they've done their Jane Doe, John Doe publication to get all of the unknowns, and then 3 months into the lawsuit, there are additional judgment liens that are on the property. You have to add those judgment lien creditors in order to extinguish their rights. But you immediately want to pursue discovery in any type of judicial situation, because you want to get to a summary judgment. You want to make sure that this moves as quickly as possible. And for all of you in Wisconsin and Illinois, you're starting to chuckle now, because there is nothing quick about a judicial foreclosure. It is like every other piece of litigation, where there are absolute a number of situations where you can get this delayed, and any decent borrower's counsel will use whatever tool is necessary to delay it. They have to assert their defenses or they're waived, and they're going to use every tool to suggest that there's something wrong with the loan calculation, there's something wrong with the accelerated debt, there's something wrong with the documentation that prevents this type of proceeding. But at the end of the process, the goal is to get a judgment. The judgment will order the property to be sold in satisfaction of the debt, and you will then get to know your local sheriff. And the sheriff really controls things at that point. And the sheriff is the person calling the sale. And certainly in terms of the the process, you want to get that forward. We had a question come in where it said something about when you file it, why not file your complaint, file a notice of lis pendens, and then just immediately file a motion for summary judgment immediately after the defenses are served? Absolutely, you should do that, unless for some reason you do need to get some documentation down. In fact, we have had, in terms of reasons to file, and that's where you end up with judicial foreclosures. Reasons to file is that you either have to fix something with the deed of trust terms, there's some mistake relating to the note or deed of trust, there's some kind of fraud or something that you need to figure out. But there could be a situation, Mike Fielding, where it's a consensual situation, because the borrower wants to get the property to the lender. They want to have this credit on their loan, And they realize that there are problems with proceeding with the non-judicial, and they would like to just proceed this way. So certainly there's a way to expedite it in terms of filing the documentation and getting them served, and then filing the motion for summary judgment and teeing it up with the court right away. And from that standpoint, certainly it's a process that would get you, an outcome. I don't know, Mike, if there was anything further you wanted to cover there, but as quickly as you can get through the judicial process. If the borrower is willing to stipulate to a judgment, it is also a fast means, but willing borrowers are not that very common. True, it's certainly, and the willing buyer is not very common, simply because they've got other creditors likely. And while they may say, lender, I'm your best friend and I'm doing everything I can, I've got ABC company that's watching every move I make. And you could potentially expose yourself as a lender and borrower if there's too much involvement in terms of planning this process, because one of the other creditors may claim that you're really conspiring to eliminate their lien, which, could be a situation. So, Joey, you want to head on to the next slide?
Thanks, Carrie. Absolutely. So, non-judicial is an alternative process to litigation that typically, where it's available, is preferred because it usually is a lot quicker. I remember back the last recession, I had a lender client who asked me if foreclosure in Colorado was a quick process, and I said, not like some other states. It takes about 4 months, 5 months to get done. And he laughed because the last foreclosure he had been talking about was judicial in Connecticut, where they told him to expect a 2.5-year process to get through the foreclosure, if you had any sort of borrower appearance. So non-judicial is usually a faster process, but it is very state specific. Actually, Colorado is uniquely specific. And it was interesting as Carrie and I were going through this, just kind of appreciating how different Colorado is from Missouri, and I would imagine other states are from one another. So I'm going to keep this high level with some commonalities, but I do want to hit on a couple of threshold things. If you've got a deed of trust that names a trustee, that's usually your first indication that you can go with a non-judicial process. Everywhere but Colorado, that trustee is going to be a privately named either entity or person. Maybe it's a person at a title company or the title company itself or a law firm. But regardless, typically in those states, the first thing that's going to happen is you're going to name a successor trustee to actually handle the foreclosure. The originally named trustee is kind of a placeholder, so to speak, while things are good. When things go south, you name a successor. And if you come across one of these, obviously you'll need to engage locally, but everyone should be aware that if you are in a state other than Colorado, and we will be stepping in as kind of the successor trustee, the firm formed the last go around an SPE solely for the purpose of being that successor trustee. That's HB Trustee Inc., and that's a liability limitation thing. Conversely, if you're in Colorado, the couple of us here, or if you've got somebody inquiring about Colorado, Colorado is the only state that uses the public trustee system. And the public trustee is actually a county level official whose sole purpose wearing that hat is to foreclose deeds of trust and release deeds of trust. And so our entire process is run through the public trustee, this public official with statute that's governed very, very closely by statute. There are, though, kind of across the spectrum, some commonalities. The first is you need to give notice of the foreclosure, right? When you commence it, maybe that's a filing, maybe that's a mailed notice, posting of notice at the property, newspaper publication. Each state is going to have its own requirements, but the common theme is that there will be notice required, and who you have to notice and who you have to research. Because anyone that you're going to want to foreclose out is going to be entitled to notice. And so you need to do the title search to see what might show up after the deed of trust was recorded, what leases are out there that you might want to get rid of. Carrie mentioned the IRS and equitable redemption. Maybe there's a judgment, there's a lien there for unpaid taxes. You're also going to look backwards in time, though, before your deed of trust, because there might be parties whose interests appear senior to the deed of trust, but might actually be junior. An example of that would be naming an HOA or a condo association who might have past due assessment liens. A portion of those assessment liens might be subordinate to the deed of trust, a portion might be senior, but if you don't notice them, they're going to stay senior or they're going to survive the foreclosure altogether. The other kind of threshold thing here when you're thinking of people to notify is you're going to want to check, there's a federal statute, the Civil Service Members Relief Act, which is basically a search that you need to do to see if your borrower is an individual, whether or not they're active military, because there are non-COVID related limitations on initiating on foreclosing if you have an active service member. The next common theme is there will be a public auction, a sale. How that's conducted is again state specific and varies depending on, again, whether you've got a private trustee who's operating according to state rules or their own rules versus Colorado, where we've got a completely statutory process run by that county official. But you'll have a sale. Depending on the jurisdiction, people will either bid live. In certain parts of Colorado, there's electronic, almost eBay style bidding, where it's all done electronically. But there'll be initial bids, additional bids, special requirements for when funds must be delivered, when the full amount of the purchase price needs to be delivered to the trustee. Usually it's a very short period of time, oftentimes same day or within a short period of time. It's not a diligence period. After that sale, depending on where you are, there will be a period of redemption. And that's statutory redemption if we're talking about post-sale redemption. Depending again on the state, there is a right after the sale for various parties to get to redeem the property, to pay the high bidder what they paid and take the property themselves versus what we've got here is equitable redemption. Equitable redemption might also be thought of as a pre-sale cure right. In Colorado, that's what we call it, is a cure right for the borrower and certain other people. In every state, there is equitable redemption prior to sale. Post-sale, statutory redemption doesn't always apply, or it doesn't always apply for every interested person. So again, using Colorado as an example, borrowers can cure pre-foreclosure sale, but once the foreclosure sale happens, they have no post-sale redemption right. Others might be able to redeem, but the borrower is out. Once you've passed that redemption period, the sale's final, and your title vests through a trustee's deed or a confirmation deed. When that deed gets recorded, the recipient or the grantee will take title subject to matters of record before the foreclosure or before the deed of trust was recorded, but should, if you've properly noticed everybody, wipe out all of those junior interests, especially those who didn't redeem. And one final point on redemption, Carrie mentioned the IRS. The IRS has a federal statutory 120-day redemption period. They are entitled to special notice of the foreclosure, separate from just the mailed notice that you might otherwise be required to give. and they have a 120-day redemption period. There's a set of regs and an IRS publication if you're more interested in how that all works. But if you see an IRS lien when you're doing your initial title review, make sure to flag that, because that will require special consideration and special treatment. Can cause lots of problems if you inadvertently fail to notify them on the front end. With that, we'll wrap up our broad overview of judicial and non-judicial foreclosures. But obviously, if you have any questions, please don't hesitate to contact either Carrie or me or anyone else on the team. We really appreciate you joining us today. Thank you.